case advanced that the mechanisms, options 1, 2, and 3, will in fact actually not deliver on the aim, which is the delivery of the affordable housing in default of developer delivery. Next point, the council itself, at all material stages, took the view that the delivery mechanisms, options 1, 2, and 3, would, as a matter of fact and law and planning judgment, deliver the aim of the requirement. Taking all those things into account, in my submission, the context that that provides means that there ought to be very, very clear words to prohibit the use of the mechanisms on their face within the committee report for those mechanisms to be found to be ultra vires. And that's the context. And I deal with that in paragraphs 18 to 27. Turning to the...
Sorry, forgive me, I'm just going quite fast to keep a good note. So that's paragraphs 18 to 27.
Yes, my lord, yes.
Sorry, I interrupted you.
No. The next proposition is that there are no clear words in this context or at all prohibiting the approach adopted by officers, or indeed requiring the approach which is said to be required by the claimant. And I would ask your lordships now to look at paragraph 28. It has, of course, part of the text from paragraph 364, with which we are now all familiar. Paragraph 364 states that if the relevant trigger point, and that's that the development has not provided the affordable housing within 10 years, is reached, then quotes, the land and sum of money, and I don't know whether it's to paraphrase Lord Justice Lewis, but to copy him, pause, sufficient for construction and completion of the social rented units would be transferred to the council to deliver the social rented units. It may not be Lord Justice Lewis's first language, but his reading in my submission was a proper and sensible reading of what the meaning of that paragraph delivers. And clearly the concept of assessing sufficiency is tied to the land as well as the money. The land and some of...
I'm sorry to interrupt you, but your deliberate pause between money and sufficient was as if to insert a comma between two words and then after units. Is that correct?
I don't think it necessarily implies a comma.
No, but never mind the grammar, as it were. The sufficiency point you're emphasising goes to both the land and sum of money.
I am. The meaning is that. I leave the punctuation to others. I think that's not material to the submissions I make. As I say in paragraph 29, clearly the concept of assessing sufficiency is tied to the land as well as the money. Both are relevant. Indeed, I go so far as to say that if, as a matter of valuation judgment, the land is sufficient by itself to meet the aim, then there's nothing in paragraph 364 which would stand in the way of that. If the land...
If sufficient only qualified the money, the question then would be, how do you evaluate what will be sufficient?
Correct, Lord, yes. And that the transfer not only goes to the money, but it goes to the money and the land.
Yeah.
So when we're looking at the concept of sufficiency going with the two concepts, the concept of transfer goes with the two concepts as well, not just the land, but the land and the sum of money are being transferred. And you can't just look at transfer in a conveyance sense as a piece of land. You've got to look at it in an asset sense, as something worth something, as I go on to say in a moment. But I was just about to make the proposition, even though I don't need to, that if as a matter of judgment, in terms of valuation judgment, the land as an asset was sufficient by itself as a matter of judgment to ensure that the delivery of the affordable houses could be occasioned, and indeed in the particular circumstances of this case, with some money to spare, then that would meet the provision. But we know in this case that for the avoidance of all doubt, option 3 also included the notional payment of £1, just to make it completely clear that it was not stepping outside the terms of 364. And option 2 is, in all of its respects, involving the transfer of land and a sum of payment, which reflects the potential for construction costs significantly and disproportionately to increase. So we say there's nothing in para 364 to be scared of. There's nothing there which comes close to prohibiting the meeting of the need, the aim of the policy. And really, your Lordship should be looking for something that really says very, very clearly, given that nobody's suggesting the aim is frustrated, this was a wrong way of doing it. And there's nothing there that does that. And I take it in stages, and I suspect it's worth going through these stages, but your Lordships will tell me if I don't need to. The first question is the transfer of land relevant to the issue of sufficiency? Well, even my learned friend Mr. Wolfe accepted that it was. The claimant accepts and asserts, in fact, that the transfer of land is an essential component of the test of sufficiency. He says, well, yeah, I accept it's necessary because without it, you can't build what you need to build. In other words, it's a piece of realty. But similarly, there's nothing that suggests that the transfer of valuable land for nil consideration ought to be ignored as part of the consideration of an assessment of sufficiency. If the council has transferred to it, or has transferred to it by another, land which is hugely and intrinsically valuable, just as a part of central London, and here one with a very valuable planning permission attached to it, at nil cost, then it not only has had transferred to it the physical area which is necessary to meet the aim, but also a hugely valuable asset which clearly can be used in both ways, as an asset against which to borrow money, and a piece of land upon which the development sits to deliver the affordable housing. And there's nothing, with the greatest respect to my learned friend, in paragraph 364 that restricts the use of the land to what I call the aerial receptor, the piece of real estate, or prohibits its obvious use or value as an asset. And indeed, I go further, and I would say that the council in such circumstances of a transfer at nil value of a very important and valuable piece of London, if it accepted that land, would be obliged to take account of whether that value by itself or in combination was sufficient to allow its experienced regeneration department to deliver the relevant housing. I go as far as to say, having been given to them as part of this mechanism, it would be irrational of them to close their eyes to it as an asset that could be used for those purposes. And there's nothing in 364 that suggests otherwise. And that's my learned friend point.
If it were more than sufficient, it would be outside the contemplation. If you didn't give any value to the land that was transferred and the money, you'd be transferring land and money more than sufficient for compensation. So you're saying that deep within this is you take the land and the sum of money together, and in combination, either or both of those is going to be enough to complete the housing. But if it was going to be the land without any regard to value and construction costs, you could end up with a transfer of money and land which was more than sufficient. It gave them a benefit, and that wasn't what this was intended. Is that your submission?
It is, yes.
Yeah.
So the words or value, which the judge put into the judgment when he was summarising it, really, is your submission? That's the only way of reading this sensibly and fairly.
It is, my lord, yes, because otherwise you just treat land as an area of square foot without a value. And land has more than two components, but two components of importance here. It's the place where the development will take place, for sure, but it is also a very, very valuable piece of real estate, which has financial consequences both for the developer and for the council. And you can't close your eyes to those, you'd be being irrational. And in fact, one can take it a step further, as my learned friend, Mr. Kolinsky, did, and I probably don't need to read paragraph 35 out, but if my learned friend is right, what he says is they get the transfer of the land for nil value, which is an asset, but that's not enough. They've then also got to get the costs of constructing the development. Now, we know that as at 2019, and these figures are all in the various skeleton arguments, the value of the non-social rented accommodation stood in the region of £52 million. So they get the land and the value that went with that. The social housing more or less paid for itself and didn't add value. So they get the £50 million, which would be associated with that grant of planning permission. But then they'd be required, in addition, to pay the £42 million to build the building as well. And as my learned friend points out, as my Lord Justice Baker put it first, that doesn't seem a very viable proposition. But as my learned friend put it, not only is it not viable, there's no realistic developer would negotiate on that basis. But it would also be contrary to Regulation 122 of the SIL regulations, because it would be considerably more than would be reasonable or appropriate to meet the need. Because meeting the need could be achieved by the use of the value of the land and, if necessary, a proportion top-up of cash. But in the circumstances of this case, as a matter of value judgment, that was not thought to be appropriate.
Well, you might submit, might you, I don't know, that in paragraph 364, the concept of sufficiency matches the concept in SIL Regulation 122.
Well, we're certainly consistent with it.
Enough and not more than enough.
Yes. Yes, exactly. And although I don't need to go here, I just wanted to test the artificiality of the learned friend's submission in paragraph 36, because it's a sort of counterfactual that establishes really how artificial and unreal the claimant's case is. Now, looking at paragraph 364 on its face, there is nothing in 364 to suggest that the land ought to be transferred at nil value. Nothing at all. There's nothing to prohibit it being transferred at nil value, but there's nothing either for it to be, nothing prohibiting it being transferred at market value. And that would be a way of avoiding the overpayment that we just looked at. All the 364 requires is the transfer of the land. Now, as I understand the claimant's case, if underlined, the transfer of the land for full value took place, with the council paying the market value to the interested party, and then the interested party repaid some or all of that back to the council in order to allow for the building works to take place, then the entirety of that proposition would be lawful. And there's simply no logic or, importantly, any requirement in paragraph 364 for stating that the acceptance of the land as an asset at nil cost is somehow inappropriate or should be ignored. And there's nothing in effect that would make the sale and reuse of the funds lawful, but the transfer of the asset as part of the assessment irrelevant or unlawful. So in the learned friend's world, we could sell it to the local authority, take the money, then have the money and pay it back to the local authority, all perfectly lawfully. But in order for the local authority just to take the money's worth is unlawful. It's just an irrational and artificial construct in my submission. But paragraph 37 perhaps most importantly, given the context that nobody is suggesting that these mechanisms don't work, most importantly, and particularly ironic in a world where the claimant says parts of the report should be treated as a legal instrument, there's nothing in para 364 which comes close to stating or requiring the full payment of all upfront costs in the way argued for by the claimant. That's a pretty specific requirement. He is saying, on no basis that I can understand, with the greatest respect to him, that the words in 364 should be isolated as meaning the full costs of the project paid upfront by the developer to the local authority. And I say, frankly, those words simply don't appear there. That concept simply doesn't appear there. The claimant is obliged not only to add words and concepts to para 364, he's required, in effect, to rewrite it. And if 364 did require that, it could have, then it could easily have said so. It could have required upfront payment of costs, and it didn't. And that is the end of the matter. So, summing up, there's nothing in 364 which prohibits the transfer of land at nil cost being treated as a matter of judgment by the council as an asset, which goes to the further judgment as to whether it has a sufficiency to construct and complete the social rented units. But by the same token, there's nothing to support the assertion that it's only the provision of the upfront costs of constructions which pass the test of sufficiency as a matter of judgment. And for all those reasons, we say there's no vires issues here. And as I say in the text, one needn't be worried about the terms of 364, not even about the terms of stipulation, paragraph 27, for example. However one chooses reasonably to read the paragraph, the court need not be fearful or defensive about the language, and that includes the term stipulate. If there is a stipulation, it falls to be considered in context, in particular, that nobody is saying that these mechanisms don't work, and for the reasons I've just set out, the stipulation is in any event met. So that's the end of the virus issue. I do very, very briefly and in passing with the rationality argument, paragraph 40. This is the flaw argument that Your Lordship identified earlier. And it is right that there is a flaw, but it's wrong that it's a flaw. The flaw was introduced by officers. It is a judgment. It is a value judgment that values will not fall below where they are in 2019 by 2029 or sometime after that. And as a value judgment, it's only susceptible to challenge in this court on grounds that it was irrational at the time it was made. And I say at paragraph 42, on this basis, Mr. Wolf's task is truly a hopeless one. And my learned friend Mr. Kalinsky didn't take you to it, he didn't need to take you to it, but the learned judge dealt with this really carefully at paragraph 66 of the judgment. I'd ask your lordships to read the whole paragraph, but this part repays reading here. What the learned judge said, interjection of Lord Justice Lewis, what he said was this: the Section 106 obligation necessarily had to deal with matters in principle because it was seeking to address scenarios which might emerge many years after the obligation had been entered into. Examining figures arising at around the time the obligation was entered into are undoubtedly part of the background to the Section 106, but so is the common assumption that values would rise over the course of the construction project, and that as a consequence, the scheme would, as a consequence, become more viable. It's not been suggested that this was an unreasonable or inappropriate assumption upon which to enter into the agreement. And later in the same paragraph, he says, dealing exactly with this option 2, option 3 point, there is no doubt that the conclusions that option 2 and 3 were fit to achieve the purpose of ensuring that affordable housing was constructed required the exercise of professional development valuation judgment. And that's exactly what that judgment was. it was a judgment passed by officers in the context of a negotiation that values would not fall between 2019 and 2029. And just to complete the point, that is echoed by similar judgments that were taken in respect of the viability appraisals, for example. There was no assumption in any of the viability appraisals of the potential for values to fall. Rather, the base value of the land and the development and the values attributed to the assets was fixed as at 2019 and couldn't go below that. So it was a consistent position across the Section 106. Paragraph 44, the adoption of a 2019 valuation floor is therefore not a flaw, it's an exercise in valuation judgment and an unimpeachable one. No rationality issue here. Then as your lordships will see, really the balance of this document does very little more than adopt the arguments of the defendant and the judge. I don't ask that I read it out. Our calculation in terms of round 6 is that 15 habitable rooms represents 3 or 4 units. The local authority says 4 or 5. I don't think anything turns on that. Grounds 4 and grounds 5, again, I don't have to read those out. I will point your lordships to paragraph 54, where I suspect rather rudely I say that learned friend's submission on discretion proceeds on the basis that the determination of the level of affordable housing somehow takes place in a rural-free, Wild West type environment. As my Lord Justice Lindblom will know, having drafted the relevant policy as part of the London plan, the negotiations take place in a fairly rigid, structured, objective way and are based on expert valuation evidence and benchmarks. And seeking affordable housing at levels which can be shown to be obviously unviable inhibits rather than encourages delivery of much needed affordable housing. And in this case, the unchallenged expert evidence was that the council could and should not seek more affordable housing than the interested party was offering, which included already the grant. And I've given you the reference to where your lordships can find that. And in all of those circumstances, not only was it appropriate that Mr. Justice Dove came to the judgment he did on discretion, I would suggest it's almost inevitable that he would have reached that view, given his understanding of the evidence, the nature of the policies, and I'd add his experience in practice. So for all of those matters, my lords, I would say that this planning permission, which is hugely important and places a very significant element of the strategic plan for London in play, shouldn't be delayed any further. Those are my submissions, unless there's anything I can help you with.
Thank you very much, Harris. Just make sure that my colleagues do not have questions for you.
No, thank you very much, Mr. Harris.
Sorry, sir.
Thank you very much. Mr. Wolfe, for the moment, although I've made sure that your icon has not vanished, your image is not on the screen.
It may be.
There you are. Yes, you came.
If I speak, I probably.
You appeared, and now you've appeared again in a larger frame. So
you may be able to pin me if that.
I can see it.
Good.
I'm not sure that pinning is part of my skill set yet, but
okay.
Anyway, there you are, and your reply, if you would, please.
I'm very grateful. My lords, I'm going to deal with the points that have been made as far as I can in the order that they were made, which I hope is easier for your lordship's notes. That means that they won't necessarily be in order of its sort of importance and in any strategic sense, but my experience is that judges find it easier to have a sort of cross-check of what's being responded to by reference to what was said in the first place. And that means that I'm going to start, as Mr. Kalinsky did, with some of the relatively smaller points around grounds 1 and 2. Mr. Kalinsky, for example, took you to the resolution and to the passage in the resolution that talks about the requirement for consultation with ward councillors. Let me just deal with that point. if it was being suggested that somehow the consultation with ward councillors could change or expand the scope of the delegation to the Director of Planning, that is plainly wrong. That they were consultees on implementation within the scope of the delegation, that they're not a mechanism to expand it, not least because they are not, or not necessarily, members of even the planning committee. That's the first point. Second point Mr. Kalinski took you to, he took you to the passages around page 193 of the bundle, which set out some broad headings for the matters that were going to be dealt with in the Section 106 agreement. And he said that is the extent of the indication of the headings in the 106 agreement. But the difficulty with that is that those headings are only the starting point, and there are elements within the body of the officer's report, and we happen to have focused on a couple of them because they are critical to the claimant's concerns, where the body of the officer's report gives more specificity about the scope of the delegation. So we don't simply start with a resolution, that's common ground. We don't do resolution plus those broad headings, as Mr. Kalinski would put it. We do both of those, and where there is more detail, particularly using language like stipulate, they are all part of the scope of the delegation. And that is what, obviously, the court needs to ascertain. Next point, Mr. Kalinski then takes you to the evidence in Mr. Gorst's witness statement. This is around page 318 of the core bundle, explaining the way in which, I summarise, but I don't think I summarise unfairly, the regeneration department, having not previously been involved by the planning department in the formulation of all of this, was now involved and identified what they saw as a problem. Mr. Kalinski called it, he said they hit a roadblock, this practical problem that they identified. Well, two things flow from that. But first of all, that matter emerging as it did only after the delegation scope was set can't change the scope of the delegation. You can't expand your scope because you hit a practical problem. And indeed, if this was a new practical problem, not only was it outside the scope of the delegation, it was also a classic Kiddesh matter. And indeed, even if it wasn't out of the scope of the delegation, it was a Kiddesh matter because it was clearly a material consideration. So whichever way one looks at it, the emergence of that practical problem, it is not part of the solution for Mr. Kalinski, it's part of the problem in working out the basis on which officers were, or we say weren't, entitled to proceed in the way they did, having hit the problem. We then get, both from Mr. Kalinski and Mr. Harris, observations about the text of 364. I'll deal with those, if I may, when I come to Mr. Harris, because he dealt with them relatively more fully, but don't take it for the moment that my silence on that in relation to Mr. Kalinski is an acceptance of those matters. Mr. Kalinski then picks up issues around options 1 and 2 and the floor question and so on. And he identifies, he explains the way in which it is said that those are consistent with his approach to sufficiency and scope of the delegation. The starting point is that if we are right about the scope of delegation, then you simply don't get into analysis of the mechanics of options 2 and 3 because they don't involve the transfer of sufficient sums of money. You only get into that, let's be clear, if you're against me on virus. And then you get into those in the rationality world, questions put to me by my Lord Justice Lindblom yesterday about whether, assuming that they were within the discretion, were they nonetheless rational? And that's the circumstances, just to be clear, in which we say they were not rational including because of the flaw, the FLOOR, which we say is indeed a flaw. I'll come back to that again in relation to Mr. Harris's submissions in due course. Mr. Kalinski then deals with the judge's approach, and here we have some difference in analysis between Mr. Kalinsky and Mr. Harris. Mr. Kalinsky says the judge is not following Mansell, he's developing a freestanding set of propositions. Mr. Harris says this is applying Mansell, and correctly so. We don't mind which of those routes one goes down. What matters is whether the principles that the judge drew from wherever he drew them and applied to this exercise are appropriate and lawful considerations. And the difficulty with that is in paragraph 4950, wherever he gets the points from, the judge refers to the ordinary principles for reading officers' reports. Now, that doesn't matter whether that's Mansell or from somewhere else. But the point is, as far as we've seen, and no time before the court has done anything different, there is no judicial thinking on how one analyses the contents of an officer's report, where, as here by agreement, it is being used to understand the scope of a delegation. All of the existing judicial thinking turns on matters to do with understanding whether the explanation given by members was a lawful one. That's why Mansell, for example, is focused upon the question of whether the officer's report is being criticised. We make no criticism of the officer's report, nor do we need to do so. The simple proposition here is that officers' reports can perform, and in this instance did perform, multiple functions. Now, not only informing members of factual matters and policy matters and so on, they are not only recording thereby the reasons for which members reach their conclusions, because it tells the reader what matters they took into account, but they are also setting the benchmark against which members make their decision. And I'll test that in a moment, if I may, by reference to the materials around in perpetuity. Questions were asked by my Lord Justice Lindblom about that. Passages within this officer's report, not all of the report, but passages within it, are undoubtedly setting the basis upon which members gave to officers the task of negotiating the Section 106 agreement. And they have to be understood in those terms. They are legally operative in framing the scope of the delegation. And that is why not every passage in the officer's report plainly, but the ones that are directly dealing with matters that go into the Section 106 agreement have to be read as part of a legal instrument.
How does anyone reading the document identify which are which do or do not?
Well, I'll come in a moment to paragraph 367, which is the passage that my Lord Justice Lindblom asked about. It's not part of our case, but there's a passage, a sentence there, which says all affordable housing would be provided in perpetuity. So that is a statement of what will happen, and that is not recorded. I'll show you where it comes from. It comes from the 2017 Affordable Housing Statement, as it says there. So it's not part of the official documents which are encapsulated in the Planning Commission, unless and until it's embodied in the Section 106.
Insofar as they're directing those negotiating the Section 106, how are those negotiating to determine which parts are legally prescriptive and which aren't?
But
in bold or with a red arrow, red hand by it?
Well, let me just test. Can I just test it by reference to the paragraph I was just looking at, which is paragraph 367 or 127, the in perpetuity point, because that's a very simple proposition. Could officers have gone away and negotiated a Section 106 agreement that didn't include the affordable housing in perpetuity? Would they have had a mandate to negotiate a 106 agreement that didn't protect it in perpetuity? We say clearly not. Why clearly not? The next question. Because Section 367 told members that would be the position. That was the position that the officer's report said was going to be secured. And the 106 agreement is the only mechanism to do that. So even without language of stipulation or anything like that, 367, as another example of this phenomenon, has to be understood as setting the scope of the officer's delegation. It's a simple example because it's a binary example. Officers could not lawfully.
Sorry, it's not just 367. You have to look at the whole report, and the whole report was about a number of things, one of which was providing affordable housing. And as part of that, they make it clear in 367 that this isn't a short-term fix, affordable housing for a little while. It's hoped to be in perpetuity. But you can't read 337 and say, there we are, that's prescriptive. You need to know all the rest of it, actually, as well, as to what the purpose is, what affordable housing is, and perpetuity is part of that. You can't, realistically, can you pick and choose just because there's a short paragraph which has got one concept in at the end, to say, therefore, those kinds of paragraphs are prescriptive.
I may be misunderstanding my Lord's point. All I'm drawing from 367 is that is the place where members are told in very clear terms that the affordable housing will be in perpetuity. Now, stripping aside...
And I'm saying that's what I'm saying. You can't... I understand what you're saying, and I have difficulty why you don't understand what I'm saying. What I'm saying is perpetuity is only half of that. You still need to know what's been provided in perpetuity in this affordable housing. And the point is, you just can't approach 367 on the basis that that's the only sentence dealing with a particular point. You've still got to read the whole report in context.
Well, Lord, what I'm doing is imagine a scenario with 367 where affordable housing was indeed being delivered. So it's mopped up all the references to affordable housing elsewhere in the report, but it wasn't in perpetuity. It was only for a fixed period or whatever period. That would be so. I'm not contemplating an undermining of the affordable housing component, which is, as my Lord rightly puts to me, is riddled throughout the whole report. It's the in perpetuity bit I'm looking at. And our proposition, it's not a necessary part of our case. I'm just using it to test the question that was put to me by Lord Justice Baker. What we say is that that is another example of a paragraph that is setting out something which is limiting the bounds within which officers can operate. Because it's not a question of discretion or judgment or evaluation in relation to that. In perpetuity is a binary proposition. So it's a simple example of where you look at that paragraph and say, could the officers have lawfully produced affordable housing, forget any debate about amount and type, but not in perpetuity? We say clearly not. So there will be, in any report like this, examples of instances where what is set out in definitive terms as to what will happen and what therefore is part of the development in a sense, and that's exactly what we're talking about. And so this development includes in perpetuity, and this development includes those matters stipulated in 364. The 106 agreement is then the delivery mechanism for those, because they can't lawfully be delivered in any other fashion. But they are as much part of the description of the development upon which members reached an agreement and satisfaction as any other aspect, as anything on a plan or anything in that planning application form or any such matter. And that component, the in perpetuity component, look, Mr. Kalinsky rightly took you to the document 246. Core Bundle 1246. But that is the 2017 affordable housing proposition. Much moved on from that affordable housing proposition, because that was when there was effectively no social rented housing at all, and much lower numbers of even SRE. And that's the document which told the council that the affordable housing would be secured in perpetuity. So one goes from a 2017 document, which is merely a letter, to a passage in the officer's report which states that as part of the situation. And we say that is as much part of the scope of delegation as anything else.
Where we came to from this is Lord Justice Baker asked, how do you determine which paragraphs are in effect prescriptive, telling you what the content of the 106 agreement has been, and which are not? And you seized on 367. And the only reason for seizing on 367 is because that's one sentence, and perpetuity looks like a hard-edged concept. It can't mean in perpetuity, because if the development is knocked down and something else is built, it doesn't mean in perpetuity until planet Earth ceases to exist. Even that has got an element within it of time frame. And all I'm saying is, it isn't an answer to, in this 700 paragraph report, some are prescriptive to say, well, I found one that has something that if we look at the second half and we look at perpetuity in a reasonable sense, it means not short term, it means long term. And that doesn't seem a satisfactory way for officers negotiating a complex deal to pick their way through these paragraphs and to see which ones are prescriptive or capable of prescription within a reasonable framework and which ones are not. So I don't think you should look just at perpetuity, you should look at the broader question that my Lord Justice Baker was asking.
Well, I use it to illustrate what I was the answer to the question, which is you need to look at the components of the officer's report, which link to things which are being negotiated in the Section 106 agreement, and say, applying the common sense reader, which is what Trump tells us to do, to ask whether there are things in the officer's report which have set the framework, that's a different way of putting the virus question, set the framework within which officers must behave. Or the officer in this case, the chief planning officer must behave. And that's not a difficult exercise. And let me put the counter proposition. The counter proposition is effectively you look at none of the paragraphs. And everything in the report, but my Lord shakes his head.
Well, that's not right, Mr. Wolf, is it? You don't look at none of the paragraphs. It's just that they don't carry the point is here, 364 argument is doesn't carry the prescriptive weight that you say it does.
Well, let me put
That's the alternative.
Yeah, well, we'll have, my Lord, I'll come in a bit to the question of what is being stipulated.
Yes.
That's a separate question. Let's just look at the language, the mechanism of the paragraph. If a paragraph which says the Section 106 agreement will stipulate X, Y, and Z, forget what the X and Y and Z is for the moment, it's hard to imagine text in an officer's report which is more apt to describe the scope of delegation of officers in relation to the delegation of 106, because it's not merely, as 367 is doing, stating a proposition about the development. It's actually directed to the Section 106 agreement and directed, we say, directly to the question of what officers are empowered to do through that agreement.
It's hard to consider 364 without actually looking at the details and what the language, what is actually being stipulated.
But my rhetorical question then would be, if in effect, even language of stipulation doesn't identify the scope of the delegation of officers in relation to the 106 agreement, it's hard to conceive of any language which would. The corollary of that, which we say is a recipe for madness, is that officers are then effectively completely free to negotiate whatever Section 106 agreement they think is appropriate without any constraints whatsoever. And we say that counter proposition is a recipe for disaster, particularly if you look at a development like this. This is a development, it's a proposal which has been considered by the Council Planning Committee on at least 2 occasions, with a report running to a huge amount of detail. The court's seen the history of it and how the councillors fretted over very specific things, and indeed very specific things relating to the subject matter of this claim around affordable housing and so on. If that whole exercise then just collapses into officers having an open-ended discretion to negotiate the Section 106 agreement, we say that completely upsets the process of councillors dealing with these matters and setting the process.
I don't think the judge said they had an open-ended discretion.
Well, my Lord, if they haven't got an open-ended discretion, how then does one identify what the scope of their discretion is? And
well, can I suggest an answer to that question, Mr. Wolf, which may establish at least or re-establish some common ground? The first thing one might say is that the resolution must be read in its own terms for what it says. That's a reasonably safe proposition, I imagine. The resolution doesn't pick out specific passages from the officer's report, which it could have done. It must, however, as is common ground, be read in the light of the committee report as a whole. It doesn't differentiate between different parts of the report, but there will be in the report particular passages, and paragraph 364 is one of them, that are explicitly germane to the business of negotiating and formulating the Section 106 agreement. And where those passages occur, such as paragraph 364, with an express reference to the Section 106 agreement, then the business of the court in construing the resolution properly must pay particular attention to those passages read in context. Now, how would that be as a sensible formulation? That doesn't in any way cut across your argument. It simply perhaps provides an answer that would satisfy my Lord's question.
Well, it does. It's an extremely helpful characterisation. As ever, you put it better than I did. And I think the answer to my Lord Justice Baker's question is in your, my Lord Justice Lindblom's explicitly germane language. You look at the paragraphs that are explicitly germane to the Section 106 agreement, and I don't have a difficulty with that. All I would say, it's not part of this case, but just in terms of the court's explanation of all of that, is that those things which are explicitly germane are not necessarily only paragraphs like 364, which explicitly refer to the 106 agreement, but there will be other passages which explain what will happen or how things will be done, which are equally germane to the Section 106 agreement. But I don't think, and I'm agreeing with Lord Justice Lindblom's formulation here, there is no conceptual or practical difficulty of identifying those paragraphs in the report which are, to use your words, explicitly germane. And I don't have any difficulty with the next step that says, in the court understanding the legal question, because it is a legal question of the scope of delegation, it will pay particular attention to those paragraphs. So as a stepping off point, I'm completely with that formulation. I can gratefully adopt it. The difficulty may be in what one understands by particular attention, because in my submission, it would be not an appropriate approach to treat that phraseology as simply meaning you take them into account, because that's not the correct approach to understanding the legal question of vires. You don't ascertain the legal question of vires for the officer here by taking into account what 364 says, not least because 364 is expressed in such crisp terms. It's not merely, as it were, a material consideration for the court to take into account in answering the legal question. It provides the answer to the legal question. So particular attention is a stepping stone, but it's not the complete story, particularly when one has a passage which is so explicit in linking to the Section 106 agreement as that one. Let me test the point this way. Could the court say, we take into account with particular attention the paragraphs of 364, but we think the officer's scope of delegation was nonetheless different to that? I say that wouldn't be an appropriate exercise for the court in doing what ultimately is answering a legal question about scope of delegation. Because we bear in mind, of course, it's unspoken in this case, but it's set out in cases like Carlton Conway, that what we're dealing with here is the exercise of the powers under the 1972 Act to delegate things, councils to delegate things to committees and to officers. So in ascertaining the scope of that question, the one that in Carlton Conway the Court of Appeal said needed particular attention, one has to take a crisp legal approach such that the particular attention is not merely one of having regard to 364, it's of giving effect to 364.
The resolution is an appropriate legal agreement. Now, I could see if there was no mechanism at all to provide for the building of the affordable housing, then you say, well, that can't be appropriate because the agreement has to provide for the building of the affordable housing if after 10 years it's not being built. So that's easy to see. What was contemplated as a minimum hasn't happened. But when you get to a concept such as appropriate, and you're filling out appropriate by reference to paragraphs in the report, is a bit harder, particularly when the paragraph itself may be said not to be clear, to say that it's making it so obvious that unless one option is pursued, upfront delivery of construction costs as per the skeleton, and if it doesn't do that, it can't be an appropriate legal agreement, because it's the resolution that is the instrument of delegation. The report just helps you understand or arrive at whether something is appropriate, I think, isn't it?
Well, I think I understand that proposition, but we disagree with it. We don't think that can be the right approach. and I know my Lord understands that. And I am picking up my Lord Justice Baker's point. I am here addressing the generic question of law, which is how one understands the scope of delegation, by reference to a paragraph which uses the word stipulate. The Section 106 agreement will stipulate. And I think I can analyse that question without looking for the moment at what it stipulates. Because it could stipulate, we could be talking about paragraphs which say the Section 106 agreement will stipulate all sorts of things. And I'm not for the moment dealing with all sorts of things. I'm dealing with the proposition of a paragraph which is written in those terms. Now, then to look at that question and say, to look at it through the prism of saying we answer the question of what's appropriate by, as it were, having regard to those stipulations, that leaves open the possibility, plainly, in that legal framing, of the court then saying, well, actually, an appropriate agreement is one that doesn't achieve the thing that was stipulated. And let's just test that by how members would have seen it. They were the readers of this report. They were the ones who were voting on the basis of this report. If it had been said at the meeting, don't worry about 364, don't take notice of 364, because the actual 106 agreement may not in the end stipulate the thing that 364 says it will stipulate. But that's complete upending of the decision-making process. Members voted for this on the basis of a characterisation of what the Section 106 agreement would stipulate. Forget the content of that for the moment, and that therefore, in our submission, completely frames the scope of the delegation for the officers. And you can't in our submission relegate the content of 364 and its expression of that to being merely a factor that you take into account in understanding the scope of the delegation. And so I'm at risk of repeating myself, but I do accept my Lord Justice Lindblom's formulation that some paragraphs will be germane, some will be explicitly germane. Characterisation. The court does indeed pay particular attention to those things, but that attention is not merely of a having regard to them characterisation, or even a due regard to them characterisation. If they are written in this kind of language, they are determinative. And the approach to the determination of them is a trump approach. It's what the reasonable reader, knowing the context, etc., would do. And the context here is not practical difficulties that came along later. The context here is members seeking to make sure, let me just remind you of the context, members seeking to make sure that in a huge development, which is to take place over a long period, where the developer has elected to put all the bits that are profitable to it in the front phase of the operation, and leave the affordable housing, which is the bit which, if you like, is the bit that's foisted on it by the planning policies, to the end, that bit at the end will absolutely be delivered. So that this isn't some abstract proposition. The context here is members wanting to put in place a mechanism that will guarantee that outcome. But as we say, that is before we get to the content of 364, that is the legal approach to be taken, and it's important, obviously not just for this case, but more generally for the correct legal approach to be understood and ascertained. Just to pick up, if I may, the points arising from Springall and Carlton Conway. Mr. Kalinsky took you to Springall. Carlton Conway is relevant because it has the passage I took you to, which explains the care which the court needs to take to ascertaining the scope of delegation. That's as far as it goes. It goes no further because it's dealing with the application and operation of a scheme of delegation in a policy where the words are clearly part of the scheme of delegation, so the issue here doesn't arise, and where the scope of delegation itself involved an evaluation by the planning officer. Because what was being delegated, as is often the case, was the power to make decisions that were either within policy or not objected to. Those are classic formulations, both of which, and there are other similar ones, require an evaluation by the officer as to whether they are within their scope of their delegation. So they're completely different situations to what we have here. There's no equivalent to read across. I'll come back. I'll park for a moment the points on the content of paragraph 364, because Mr. Harris dealt with them more fully in his notes, and I'll pick those up when I come to them. So I've dealt essentially with ground 1 and not for the moment with ground 2, because Mr. Harris dealt with it rather more fully. Can I then deal, if I may, with grounds 3 and 6? this is the developer fallback position. Can I again slightly remind the court of the context for these points? This entire scheme is essentially conceived as a construction, in relation to the residential component, I should say, not all the other bits, as a build-to-rent proposition. Notwithstanding that, because of the way the development plan works, SP6 is the operative policy. So SP6, with its 50-50 split between social rent and other forms of affordable housing, is the operative policy for the whole site as build-to-rent. There is also, emerging over the horizon, a different policy applicable to build-to-rent, P4, but it's not part of the development plan, and as the officers identified correctly, therefore of limited weight. The developer wants to keep open the option, unlikely is the word used in the paperwork, unlikely option, that having done build-to-rent on the east side, they may then want to do instead build-to-sell on the west side. So it is that situation in which they're flipping build-to-rent to build-to-sell on the west side, which triggers the issues in relation to grounds 3 and 6. So the migration is away from build-to-rent and towards build-to-sell. In that context, I would like the court, if you would please, to turn up the paragraphs that deal with this. So this is in the officer's report at paragraph 127, sorry, page 127, but first of all. Paragraph 365, exactly. So the first part of the paragraph is explaining the situation. And then the second part says this: the developer would notify the council of the intention to build the west side as build to sell, and the affordable housing requirement for this would be 50% social rented and 50% intermediate. But what is being done here is in recognition of the fact that the overall scheme is not compliant with SP6, because it doesn't generate the 50-50 split, is to say that in the event of this situation, we will have a mechanism which will move us towards the 50-50 split. So the only thing in the, again, scope of delegation about the framing of the split to be achieved down the line is a reference to 50-50. And that is SP6, beginning, middle and end. So what officers are being told when they come to frame the Section 106 agreement around this thing is, having not so far achieved the SP6 50-50, this will be another situation in which we can seek to do so. And that is the beginning, middle and end of the scope of their negotiation on that point. 404 returns to it. I can ask you to turn to that on page 132. In the event that the west site is delivered as open market for sale, the review will need to take into account the policy requirement for a different 10-year split of 50-50 social rented and immediate. That, again, is a reference, and only a reference, to SP6. Then there's further stuff on social rented units. I'll come to that in relation to round 6. But in terms of the approach, what we are being told here, what officers are being charged with doing, is a review mechanism triggered by the build to sell election, which will seek to achieve what hasn't been achieved so far, which is the 50-50 SP6 split. And there is nothing within that which invites or allows consideration of other policies or numeric limits. And that is why our starting point on ground 3 is to say that the inclusion within the mechanism of the limit of 15 is outside the scope of that delegation, because that delegation did not limit the 50-50 aspiration in any numeric way. And the fact that that 15 is derived from P4, I'll come to in a second, it is further outside the scope of that delegation, because the scope of that delegation was all about securing SP6 50-50 nothing more and nothing less. So
Mr. Morgan, what are you going to come on to? It needs to help me say where you floor, find that word, floor is in Mr. Kalinski's paragraph 63.
I will, my lord. Yes. As a refinement down the track, I'm approaching that.
I'm pretty sure you're coming to that.
So first step, it's 50-50 derived from SP6, and that's the beginning, middle, and end of it. Second point is that doesn't allow for a numeric limit to be set in advance, which is what's happened here. Third point, it doesn't countenance the application of a different policy, for example, P4 in the calculation. Let me just pick up why the application of P4 is so erroneous here. It's not only precluded by the virus point, but let me just return to the starting point here, which is the east side was always, and even under this regime, remains build to rent. It was build to rent, to which, along with the rest of the site, SP6 was applied to give you the 50-50 requirement. So the question then is, when you then flip the west side to build to sell, what possible basis is there for then applying freshly out of the blue and unconnected with that P4 to what you've already done on the east side, which was always going to be build to rent? The council has in its analysis, correctly, because it's the statutory development plan, applied SP6 across the whole site. There is nothing in the flipping of the west side which justifies departing from that in relation to the east side, which is completely unchanged in this proposition. So there's no basis at all to suddenly pull out of the air P4 and apply it to that side. So that's the next step in the process of where they go wrong. Even if you could apply P4, so you were somehow treating that freshly and for no obvious reason connected to the new situation to the build to rent which has already been built, and so therefore you're applying the inapplicable emerging policy bizarrely. Let's assume for the purpose of what I say now that you can do that. You go back, and I do draw the court's attention back to the table that we put on page 166 in the core bundle. You would do that. Let's somehow, we're into this counterfactual world where we're doing a fresh planning evaluation of the social housing requirements of the site, and we're applying P4 to the east side and SP6 to the west side. What you do is you apply P4 to the east side, and you apply SP6 to the west side, and they generate for you the social rented requirement for this development, this entire development. And that is the calculation we've done on page 166. And that gives you, applying, assuming you can, the P4 12%, a need for 192, applying, as you always have to do, the 50-50 on the west side, that gives you 192 and 307. And so the social rented requirement for this development is 499. That's what the development...
Isn't the floor in that? You haven't actually got 192 in the east side. So if you include them both in the east side and the west side, aren't you actually getting 192 extra? Or am I missing something?
I think, with respect to my lord, I don't put you are missing something.
Right. Then you better tell me.
Well, this is one development. This is one development. If you are going to apply different policies to different parts of it, which, as I say, there's no basis to do, but let's assume for the moment you are, you apply those different policies to each part of it to work out what the overall social rented requirement is. And the overall social rented requirement is 499. Now, if you were doing this as the initial exercise, you might say, well, let's have the 192 that relate to the east site on the east site. Let's do 192 on the east site to deal with the east site's P4 generated requirement, and let's put 307 on the west site to deal with the west site's generated SP6 requirement and split them that way. But because of the way this scenario arises, at this point, the east site has already been built. So the 192 requirement which it's generated has to be added to the 4307 requirement that the west site was always going to need to generate to give you the 499. You don't take away the number you first thought of as if these were somehow two separate developments. They've always been one development, and what's happened here is that the developer's flipped its election. Otherwise, I mean, as it happens, Mr. Kalinsky's calculation takes it as one step more problematic because he deducts the 192 twice. But you simply don't deduct the 192 in that way, because what you are seeking to do, assuming you can apply those two policies to separate parts, is work out what the total social rented housing requirement is, 499 units, and then get that somewhere. And because the east side's already been built, the only place you can get it is the west side. You've already committed to building 450, and so on this uplift version, you need to commit to building another 49. And it's as simple as that. It's as simple as that. You don't take away the number you first thought of, as if the west side somehow, its total housing requirement didn't generate the SP6 50/50. You don't subtract anything from it. Now, as I say, Mr. Kalinsky's analysis.
The purpose of this is when you switch the west site and you're working out what extra housing to have because you've switched the west side to build to sell instead of build to rent. And you need to know what you need to put in to take care of that. And why should you be using the 192 houses that you transferred from the east to the west side to work out the uplift from the flipping of the west side?
You're not trying to work out the uplift, you're trying to work out what the total requirement of the whole proposition is. And we only get into this calculation, because of the erroneous application, fresh application of a different policy. We don't get down this road of working out those different requirements. If we go back to the original calculation was we have an overall requirement for social rented housing, some of which is attributed by application of SP6, arises by application of SP6 from the east site, some of it arises by application of SP6 to the west site. What the council rightly did in the first scenario was to add those together and say to the developer, where do you want to put it? And the developer said, we'll put it on the west side. Absolutely fine, as long as you've got a guarantee mechanism, right? That is the same approach that then needs to apply if you are doing the new evaluation in this newly triggered situation. Now, assuming for the purpose of all this that they're entitled to apply P4 out of the blue, you simply repeat that exercise. You don't do the staged exercise that Mr. Kalinsky's evaluation would do. And test it this way, that is not what the council did in the first place. Imagine if the developer had come along first off and said, we're not doing build to rent across the whole thing. We're doing, as our first proposition, build to rent on east, build to sell on west. Imagine if they persuaded the council in a planning way that P4 applied to one and SP6 applied to the other. The council would have done exactly the calculation that we've done on 166 and said, you've got to put 499 somewhere. You can put them how you like, but you've got to put them somewhere. The council would not have replicated at the outset the exercise which is now being contemplated for how many years down the track in this buy-to-sell election.
How does the 499 relate to the 3358?
It relates, well, so 1604 and is the total number of habitable rooms.
I worked out what the 3358 is.
Yeah.
Is there a relation between the 499 and the 3358?
Yes, well, there is, but you have to work it through the table this way. So 1604 times 12%, which is the P4 figure. So if you were looking at the east side as a build to rent in total isolation and applying P4 to it, that would generate a policy requirement for 192 habitable rooms. If you then look to the west side, 1754, and applied the SP6, 17.5%, which is 50% of 35%, if you want to know the derivation of that, that would generate 307. those two added together, 192 and 307, are 499.
Yes.
So the 499 and then the 3358 is the total number of habitable rooms. So the 499 is related to the 3358 really by working your way. If you started at the top right hand corner, 3358, you work your way sort of anti-clockwise around the table because it's at the risk of repeating myself, which bit of the 3358 is attributed to the west? Apply one factor to that, which is attributed to the east, apply the other factor to that, add those two together, that gets you the 499. So the
Just tell me again, forgive me if I'm a bit slow on this. Why don't you deduct the 192 from the 1754 before you make the calculation?
Because this is a single site, at which there is a generation of affordable housing across the entire facility, and the council starts off by saying, what is the applicable policy? At the beginning of the process, they applied, quite rightly, SP6. Now, if it were right that you deducted the 192 or whatever number, then that would have been deducted in exactly the same way in the original calculation.
How many would have been built if the whole thing was built together?
If the whole thing was... Well,
if east and west were built together, what would the figure for...
what would be a
affordable housing be?
What would be a, I think the question actually is what would then be a policy compliant figure?
Correct. Thank you, my lord.
Well, we've got the council's version of that on the developer's primary case, which is built to rent across the whole thing. SB6 applies, and you end up with 116 habitable rooms, which is a slightly different number as you've heard. Depends how you configure. Sorry, 116 units, which translates into a different number of habitable rooms, or the other way around. And that was the approach the council rightly took at the beginning. SB6 across the board generates a total number, and the developer can put it where they like. And they happen to have chosen to put it in the west side. That approach can't change because you're now doing this in sequence. Imagine if you didn't.
I'm sorry, I just want the number. If you looked at both sites together, notionally, of course this is doing it notionally, imagine that they are but one single large site. What would then be the policy compliant figure?
I think, well, it's not calculated as such, but if we look in the, we've got the, it's page 126.
126.
I'm not sure if we've got a table that allows you to in the paperwork, which allows you to easily translate to reconcile the habitable rooms approach.
So 126 of what?
Of the supplementary bundle. So it's in the officer's report. Sorry.
Right. Sorry. Thank you.
I'm not sure we've got a single piece of paper that gives you the I'll be correct if I'm wrong, and we may come back to you on this if I am wrong. This table is prepared on the basis of units rather than habitable rooms, and that was got, but the 50-50 SP6 question applies whichever way you look at it. It was that got you to the 116 total units of social rent. That was the developer's offer, and that is falling short. That's only that's said to be, if you look in the left-hand column in paragraph 362, 38% of affordable housing in habitable rooms. So that's the shortfall. That's indicating a shortfall from the 50-50 policy compliant position. Sorry, actually, I can answer my lord's question in a slightly more easy. I'm being very slow here. You haven't got the figure, but go back to 166 in the core bundle. I'm sorry, I'm being very dense here. 166 in the core bundle. That table gives you the position if you were splitting the policies as there. The policy compliant position, the SP6 policy compliant position is actually very easy to work out. I can't do the maths in my head. It would be 3358 times 17.5%. The Lord General just a little softly ahead of me there.
I've done the maths, but I'm not going to disclose the figure in case my maths is wrong.
You can disclose the figure with a caveat that your maths might be wrong.
Is it 587? Miss Stackman will tell us the answer to that.
Yes, I did 35. I hadn't divided it by 2, so that's what I was just doing. But yes, it's around that. Yep.
So 587.
My lord's mentioned arithmetic powers of still much.
So I'm grateful to that. I got there very slowly in my clunky way in the end. So that would be the SP6. That's the 50-50 requirement that the members set the operative, and that's been distorted in 2 steps. One by applying P4 out of nowhere to the east site, when it's no part of the application of that site, and then secondly by doing the 192 deduction, and they are separate floors. In terms of the further point about Mr. Kalinski's explanation and skeleton argument, all that, his paragraph 63, which has several layers of subparagraph, his 63C little 1 deducts the 192 twice. So we see that at C1, which is on page 64, and then again at C6. So this actually compounds the problem, and this is, if you like, just a sort of arithmetic step of deducting the 192 twice. But as I say, that's a gloss on it we don't even need to get to, because as I've indicated, I won't go back around it again, the members set the officers off on a 50-50, which is implicitly SP6 basis. There's no basis to embark on an SP4, a P4 calculation. And even if you do, you still have to treat the whole proposition as one site, and follow the approach, just to emphasise the point, which the council followed in the first instance, which is the calculations we've seen. They didn't do the equivalent of the 192 deduction in setting the original aspiration, and they were quite right not to do so. And there's no basis to introduce it now. And if there were a basis to introduce it now, then it would have been what they would have done previously, and it's simply not appropriate.
Can you just remind us where the judge deals with this point?
It's his paragraph 69, I think. He doesn't deal with so just to emphasise the point, my lord, we put this in our skeleton argument, that the judge in his analysis, as it were, leapt over the first and most important step of our submission, which is that the officer's report specifies, or the member specifies through the officer's report process, the 50-50, that the judge jumps over that. He doesn't actually answer that submission, our primary submission. He went straight into dealing with the mechanics around P4 and the 192. So he didn't actually answer our primary case, which was, you don't get into P4 and 192, you just look at the officer's report, that's beginning and end. He jumped over that into 69.
If you look at paragraph 68 and 69, looking at it very quickly again, the impression that I formed at the time that looks to be borne out is that he didn't read 40, whatever is, whichever policy paragraph, officer's report paragraph you would say is prescriptive. He thought it was to be dealt with under the review in the event that there was a switch in the west side to sell housing. That's in paragraph 68. And that's how he understood it, that you didn't have a requirement of a 50-50 split. What you had was a review, and that was a different second stage exercise from what you would have done at the initial stage. And then at 69, he considered your complaints, having already in effect decided that it's not an application of a 50-50, it's a how to conduct a review if the west side switches to build to sell, reading paragraph 68 to 69, but I may be wrong, so I just looked at it very quickly.
I completely agree with my lord, that's how the judge did deal with it, and it's the sort of earlier what my lord just put to me is where the judge, he treated it as if it was, if you like, an open-ended review, just, dear officers, come up with a review mechanism in the event of a buy-to-sell flip. What that fails to do is it fails to look at 365 and 404, which I'm not saying have a review mechanism in the event of a build-to-sell flip. They're saying They are specifying the parameters of the bill of the review mechanism and specifying.
But I mean, he disagrees. He did not deal with it. He thinks the report doesn't require what you say.
But, the closest he comes, the closest he comes is in the middle of 68, where he says it is notable that the officer's report did not contain any detailed description as to how the review was to be undertaken in the event that ... Now,
and in the next sentence, the committee report left open how these particular requirements were going to be tackled.
Well,
interpretations through the additional housing requirement. He's taken a different view, looking at all the documents than you are putting forward. It's not that he's failed to address your paragraph, your 50-50 split. He's simply saying that he doesn't agree with it. Well, I can see.
I'm not going to quibble with that characterisation. If that's the characterisation, so be it. But in which case, he's not giving any attention at all, let alone the particular attention that we canvassed earlier on, to what paragraph 365 and 404 actually say, because it may be that, well, it's clearly the case that they don't give the nth degree prescription of how the review mechanism is to proceed, but they do set the parameters, and the parameters they set are very clearly that the policy context for all of this is achieving the 50-50, which we haven't so far been able to achieve. Now that the scheme has changed, it's not a license to start again with a fresh planning analysis.
I mean, he's quoted 365 and 404 in the immediately preceding paragraph, doesn't he? And you say that I'm not sure you can say he hasn't paid particular attention to them. You say he simply misunderstood them.
We can quote those paragraphs earlier on in the body of his judgment. So he's
I'm pointing out that in the paragraph immediately preceding paragraph 68, he's referred and quoted from 365 and 404. So I was questioning whether in the circumstances you can say he hasn't paid attention, or particular attention to those paragraphs, but rather would be submitting that he simply didn't understand what they said.
His reference to them in those paragraphs is very incomplete. Now, if that's characterised as not understanding them, there's different ways of putting that, and I don't want to fall out over how you characterise it.
No, well, I just wanted to know how you did put it. I mean,
he hasn't given any effect to those elements of 365 and 404, which refer to the policy requirement, which is to be applied in the review. And that is only, it's not put as SP6, but it clearly is SP6 because it's the 50%. It's SP6 the only place you can get 50% from. And the judge has
to deal in paragraph 67. He sets out 36, or refers to 365 and 404, and then he deals with addendum number 1 and addendum number 2, which says the section 168 agreement will set how this should be addressed. That I think is what Mr. Kalinsky was submitting this morning.
That's
absolutely right. At the addendum and the report as a whole, that apart from saying that 404 was fixing or prescribing a requirement, when you read it with addendum 2, it was to be dealt with in the legal agreement, and paragraph 404, read in context, wasn't prescribing what would be in the legal agreement. I think that's what Mr.
Well, it's absolutely right that you read them all together, because clearly the members had them all together and read them all together. They're all, in our submission, of a piece. They all, the policy requirement that they set out and established is the 50-50, which is SP6. That is identified as the basis upon which the officers are to approach this aspect of the Section 106 agreement. And indeed, if we look at the addendum report, and this is another example. Addendum report number 2, page 256 running to 257. This is where you've got it describes an unlikely scenario. And it's a different form of language, but again, it explicitly links this to the Section 106 agreement because it refers to what the Section 106 agreement refers to the Section 106 agreement, and then it says the committee is entitled to consider the application on that basis. So if you read those 4 paragraphs, 365, 404, addendum 1 and addendum 2 together, all 4 together, you have a very clear linkage to the 106 agreement. You have a very clear injunction that's the right word, to members to say you can proceed on this basis, and you have not detailed prescription, I accept, of the review mechanism, but the one thing, if you like, that is established is that the policy basis for it is going to be the 50-50, which by implication is SP6.
Could we just look at paragraph 69 and just, if you could just say where did you say the judge went wrong when he was in the specific application to this case?
Well,
So do you accept that there was nothing unlawful about the use of P4?
No, I don't accept that, my lord.
So that's where it goes wrong.
That's the first step of where it goes wrong, and I hope I've made clear that my submission is in layers. So the first step is that those passages which direct the 106 agreement and upon which members are explicitly entitled to consider the application, that's the sort of injunction,
yes,
32257, are all and only about SP6, and that is set to be the aspiration that you go for. So P4 just doesn't come into it, can't come into it. And stepping back to
so he's wrong about that. So he's wrong to accept the defendant's submission to the second sentence, which is the same as the first sentence. You don't accept the choice of planning policy is a matter of planning judgment in this context, then, do you?
No, I don't, because the officer's report has, and it might have been, it would have been at the beginning, the councillors could have said, for example, complete counterfactual, we're not going to just apply SP6, which is the statutory development plan, through the prism of section 38(6), etc. We're going to treat P4 as having significant weight somehow in that process, query legality of that, but they could at that stage have brought P4 into play. They didn't, rightly not. I then say, how does P4 conceivably come into play at this subsequent stage? When
if he's right and you're wrong about that,
yeah,
is the rest of the paragraph objectionable?
Well, the problem
is he still wrong? If he's wrong on the right on the principle, contrary to your submission, is the rest of the paragraph all right, or does he go wrong again?
He picks it up at 70, and he says, whilst the claim...
No, I'm in 69. I'm talking about...
I understand that, my lord, but 70 is him recognising the bit of 69 which we pick up on. Because 69 is mostly just setting out the maths.
Yes.
Right?
But he accepts Mr. Kalinski's maths.
Except Mr. Kalinski's, well, maths and formula, if you like, not the right word. Yeah. The flaw in that, FLAW flaw in that, is in the somehow taking out the 192 from the east side, rather than saying this is a single development. Even if you're applying P4 to part of it and SP6 to the other bit, you add together what they generate as being the need for this development, and you deliver that somewhere.
If you do treat it as two different sites and do take both policies into account, doesn't it, Mr. Kalinski's approach make sense?
No, absolutely not, my lord. I was a bit rude. I didn't mean to be quite so abrupt.
No, that's all right.
It
wasn't rude.
You don't apply the policy as if these were somehow two separate developments coming forward. Development A, ring fence the calculation around that, and then development B. It's not as if the developer has come along and said, I want to develop this acre of London, and then said, well, I'm going to build social housing for that on some other acre of London down the road in a different scheme. This is all one scheme. This is still one scheme. And as I say, test it this way. If it were right to do this, take away the east side number from the west side before you calculate the west side's requirement, if that were right as a matter of planning, logic and law, that's what the council would have done in the first place. It would have applied SP6 in doing it, so it would have said, let's just play through the formula, let's work out the SP6 requirement for east side, let's take away that from west side, and then work on the residual of the west side. That's what this calculation does, and it would have been entirely wrong at that point. It doesn't get any better. It doesn't get any better by the fact that it's being done with two different policies rather than one policy. It doesn't get any better by the fact that it's being done at this later stage in time. It's just as flawed. So, as I say, if that were this approach to manipulating the numbers, I don't mean that in a rude sense, it absolutely is an exercise in taking away the number you first thought of. And that's why I said, to crystallise it, I mean, it's the same point as when I'm dealing with Mr. Kalinski's submissions, because they run together, rightly so. And, the judge accepted Mr. Kalinski's submissions before, sets it out, and Mr. Kalinski repeats that. The flaw is assume against myself you can apply P4. The flaw is in treating these as somehow two separate developments, where the second development isn't actually what it is. It's a different development to the one that it's generating. And that's how it works.
The site, the west side, which is part of one development, was originally going to be built to rent, and now it's going to be built to sell. And you're trying to deal with that different factual situation in a review mechanism. And I'm not sure yet that you have to approach the different factual situation when you're dealing with a review mechanism, which may be a viability review mechanism, by going through the same hoops that you went through the first time.
Well,
I suspect that's what the judge meant.
Well, that may be what the judge meant. I say to go back to
you say he was wrong.
But yeah, precluded by the terms of the officer's report, step one. But even if that were right, let's just look at that exercise. In that exercise, what has been done is to apply a different policy to the bit of the site which hasn't changed on this scenario. Suddenly they're applying P4 to the east side, when on this scenario, the east side has simply done what the east side was always going to do, which was to be built to rent. So that's the even if it's sort of not precluded by the virus question, that's the indefensible step there, because east side is unchanged on this side. It has just gently chundered along and delivered the build to rent it was always going to build. How come you suddenly apply a different policy to it now? No possible logical basis to do that. Even if you do, the west side is now built to sell, but it's still generating the same number of rooms, the same number of units, it's just a different tenure model. So it has to generate the same number of SR units applying SP6 as it always did. And you simply add those together. I'm just repeating myself.
I suspect we've been around this now a few times. If there's anything else you want to say about ground 3, please add it now, and then we can move on.
Absolutely, my lord. Ground 6 is the distinction between social rented and social rent equivalent. They are differently defined in the Section 106 agreement. You have the definitions on 432 and 433. The critical components of that, about which there is no dispute, is about ownership and rent levels and tenure type. Members saw that as material because they saw benefit rightly when the developer's offer changed between January and July to flip from generally SRE to generally SR. So there's clearly a benefit of that. And to go back then to what the officer's report said about this review process and what we've just been looking at, paragraphs 365, 404 in the addendum report, they are all talking about an uplift of social rented housing. They are explicit in that. Now, to pick up a point that I think may rise from Mr. Harris's submissions, you don't need to say social rented but not something else. If you put in place a mechanism that will deliver more social rented housing, you don't need to say more social rented, but we don't mean something else and something else and something else. It's explicit, it's clear that what the more needs to be is social rented. So there is no mandate to go beyond that. It's a virus question. And again, if a practical issue arose, which appears to be the proposition about how that would be done in practice, if suddenly it dawned on the officers later that this might cause some confusion, again, outside the scope of their delegation and or a material consideration that needed to go back to members. They can't simply say, we didn't think of this before, let's do something different, because members have framed the basis on which this planning permission is to be granted. There was just one further subtle point around the distinction between social rent and social rent equivalent, which I can't let lie, which is that Mr. Kalinsky pointed out. It's the document that the affordable housing document that we had before, that talked about tenant safeguards. So this is page 247, 248 of the core bundle, and he took the court to passages which explained, I think this is page 252, there's a passage at the foot of 252 which Mr. Kalinsky took you to that says, no, this is in the SRE category, no tenant will be asked to move from an apartment other than where they wish to do so. So that was signposting, if you like, a potential right which doesn't ordinarily exist to continue with an assured short hold tenancy. In other words, a right to stay after 3 years. So that was what was being contemplated. Mr. Kalinsky then pointed you to, but didn't take you to, Mr. Harris's note on the differences. If I just do that for a moment, to page 258, this is the passage that Mr. Kalinsky took you to, 258, paragraph 3.4. Where Mr. Harris, correctly characterising the Section 106 agreement, says this: those paragraphs enable a tenant to remain in occupation until the end of a 3-year tenancy. Paragraphs, he gives the numbers, specifically provide for the developer to permit the households to continue. Now, I could take you, if we need to the paragraphs he mentions of the Section 106 agreement. You're right. What the Section 106 agreement does is permit the developer to allow an extension. It's quite a complicated set of paragraphs. They don't require. So the Section 106 agreement does not in any sense somehow significantly gloss the difference between a short hold tenancy and a secure tenancy in the ability to carry on, I don't want to use the word in perpetuity because it's a loaded word, in a secure basis. So even only if you look at the headlines, the headline differences between these two situations, social are material, and members were right to say that they were material, and officers, in departing from that, were outside the scope of their delegation by reference to 365, 404, and the 2 bits of the addendum report that refer to that. And that's ground 6. Then we had grounds 4 and 5, ground 4 in particular, the question of misleading or erroneous information. Can I be very clear about what our case is and isn't, and always has been, it hasn't changed. It is clear that members knew that the grant wasn't guaranteed. It is clear that members knew that the developer was going to proceed come what may. They're committed regardless. The misunderstanding was in the confidence attached to the delivery of that grant, and the difference between something being in principle in the bag, which is the way members were told was the position, and the developer merely being in the position to make an application. And those, we say, on any view, are materially different. So members were misled, and or there was a factual error as to the confidence stroke certainty of the grant. Nobody says that they thought it was absolutely certain. No, that's not our case, and it never has been. It was about the certainty of the grant. And that was material, as I'll come in a moment, to the question of what's reasonable of the housing offer as a whole. Mr. Kalinsky took the court, in terms of the concerns, took the court to passages in the addendum report, and this was page 248 of the supplementary bundle, where the 35% campaign was asking for confirmation that the affordable housing would be delivered regardless. That's my paraphrase, but that's essentially the point. And he said, look, that's what the 35% campaign were concerned about. They got that. They got that reassurance. That was the end of the matter. What Mr. Kalinsky didn't take you to was page 222, which is, as I said, I think in my opening submissions, because there were representations made at different stages, consultation response at different stages, you get them at different points in the process. And at 222, in the earlier characterisation of the 35% campaign submissions, this is paragraph 863, but it's a very long paragraph, just by the lower hole punch on 222, the 35% campaign was saying this, this is earlier in the history, slightly earlier in the history because it's evolving, Further information regarding the possibility of GLA grant money for the proposal. This application should not be determined until this is resolved, as it would impact on the amount and type of affordable housing. So they were later on concerned to pin down that this was in the bag regardless of the grant, of course. But they were also concerned about certainty around the fact of the grant and how that impacted on the quantum of housing that would go into the picture. And that was always our case. That's always been our case. Can I just almost signpost you? Page 142 in the core bundle. Paragraph, we put in several, this is a summary of the ground. But the summary of the ground at paragraph 11 on page 142, 11A, had members understood that there was no guarantee they would have had potential concerns about deliverability. 11B is exactly the point that I've been canvassing yesterday and today, which is, had members realised that the deliverer, notwithstanding a much higher level of uncertainty than the one they've been told about, they might well have said, let's negotiate, the words of 3.12, for more. And they would have had that contemplation in the knowledge of the fact that since January, the developer's offer had increased, with the only thing that had happened in that period, the only two things that had happened in that period, having been the emergence of the possibility of the grant and the council's position taking. In other words, go back to January, the council's minded to refuse contemplation on the meeting of the 30th of January that was possibly going to formulate reasons for refusal. But members would have known that this is a developer, this is a situation in which, notwithstanding the fact that in January they were told this is the max you can get, they were able, in fact, to get more, and presumably lawfully get more. That's the other proposition that's being put. So, contrary to what Mr. Kalinsky puts it, our case has not pivoted, that was his word. Our case remains exactly the same, absolutely the same throughout. And we say the judge is simply wrong in his characterisation of the misleading stroke erroneous facts because he focuses wrongly, given our submission, on the issue of certainty, which is not the thing we said was misleading. And he goes worse than that because he says that the members, it was correct to say that this was an in-principle agreement. So he takes a view, we say wrongly, on what in-principle agreement means. We say wrong, in-principle agreement is not the same as you can apply and you might get. That's a completely different proposition. So we do say that there was a misleading as to the confidence levels. And that feeds in, to some extent, I've bled into ground 5, which is the section 31 discussion, because this was a context in which the court couldn't say what would have happened. And Mr. Kalinsky, I think Mr. Harris must let the cat out of the bag. And Mr. Harris said, the judge was drawing on his expertise as a planning practitioner. And that's a red light to say what we're doing now is stepping into the sphere of the planning judgment, speculating on what would have happened. No basis for that whatsoever. So that deals with Mr. Kalinsky. I just need to make brief points on some of Mr. Harris's points. I think the points here. So Mr. Harris's note, paragraphs 12 and following this is all dealing, going back to our old friend 360, the scope of delegation in 364. His approach here is to say there's nothing in those paragraphs which preclude or prohibit transfer of value rather than money. We say that's not the correct approach because that's not the way that the officer's report is framed. You don't look to see what's prohibited, you look to see what's allowed. This is about scope of delegation, and you can infer the one from the other. His other point, paragraph 22, is he says there's no evidence that this won't work. Well, with the greatest respect to him, that's not the question. We don't need to say this won't work because it's the opposite situation. This is designed to be a mechanism to ensure delivery of the houses. We don't need to demonstrate that there's a risk it won't work. The point is, as a matter of legal requirement, it was to ensure the delivery. The next point, if I may, is Mr. Harris's paragraph 31, And this is where we get into the nitty-gritty of the language of paragraph 364, and I'm sorry we're going back over that. My Lord Justice Limblom rightly picked Mr. Harris up on his clauses and implied commas. And we say those things do matter, and we need to look at what 364 required and the framing of it. Because the proposition against me is that this could all be done just by transferring land. In other words, no money needed to move across at all be done just by transferring land. For that to be right, we could, if that were right, we could strip out the references to money in this paragraph. But let's do that, if I may. So that the requirement is the land, miss out the next words because they're a reference to money, sufficient for construction and completion of social rented units. Let's imagine this paragraph didn't talk about money at all. The land sufficient for construction and completion of units. What that would have delivered up for the council at this point of non-delivery of the 116s is a piece of real estate, just the piece of real estate on which it was going to build the social housing. No more asset, that would have been the requirement. But there's nothing in there which refers to the land or additional land which we can then sell or mortgage or make money out of by putting commercial property on it to generate the construction money we need to build the social rented units, which is what we're trying to deliver. And that is why the question of pauses and commas is so important. Because the only reference in that paragraph, the stipulated bit, to something which is going to give you the money to pay the builder, the company that builds these things, the only reference to that is in the sum of money sufficient. Because to say sum of land, land sufficient doesn't give you that. It simply doesn't give you that. And that is why, for the judge to include in that paragraph, and it is, my Lord Justice Baker was very prescient yesterday in saying that's perhaps a tipping point, to say all value just doesn't come into it, And there's a perfectly rational explanation for why that's the case. The councillors wanted to secure a mechanism that would deliver this up, come what may, whatever had happened to property prices, solvency or whatever. This is the long-stop fallback to make sure this happens. This is a cash-strapped local authority like every other. Doesn't want to have to put its hand in its pocket or work out some sale or leasing mechanism. It simply wants to deliver up these units in the event of
what is the land, if we follow your and strip out the words, what is the land we're talking about?
Well, it could have been a plot big enough.
This is supposed to be descriptive.
Yes, if it had simply said the land sufficient for construction of the social rented units, the developer could have transferred, I don't know how big a plot one would need to build 116 flats on, a plot big enough to build 116 flats on. Said, there's a piece of land within this overall site, big enough for you to build 116 flats on. And that's all you get. And the council would have then had a lovely piece of land in central London with planning permission, but no way of funding the construction.
Sorry, I thought it would have to be the site that was the subject of the application.
Well, it would have to be part of that site, but it's not prescribing which bit of the site.
So they couldn't have to be the land with the commercial units. There could be a different bit of land within that application site.
On the face of that, yes.
Doesn't it mean the west side?
This is not on this formulation. Couldn't have insisted on if
no, but it's the land. It's the land.
No, the land.
Following your hypothetical analysis here, we strip out the word sum of money. It would be land sufficient. If you're right, if it was just enough land to build 116, it would be land sufficient. But it doesn't say land, it's just the land. That must surely be the west site, mustn't it?
It's only a tiny bit of the west side, because if you recall, the west side has many sub-bits to it, because there's the tables I took you too much earlier, I won't take you back to it. You know, W1, W2, W3, W4, and even sub bits of all of those things. So it's not that the council gets to the west site under that formulation. But all that would, as it were, mandate is the land sufficient to build the houses, and no money and no ability to do it. So that's why the way this paragraph has to be understood is that the putting the council into the position of being able to fund the construction on the land which they're getting, that's not in dispute, is in the sum of money. So as a matter of the plain language of the paragraph, there isn't an option, we say, there isn't an option to say, we're not giving you any cash at all, we're just giving you a bigger piece of land. It's just not part of the what's contemplated by that paragraph, and for good reason. Now, we're not saying in a would have been irrational. Members would not necessarily have been wouldn't have been irrational to say to do it all by land and values. Members wouldn't have been irrational to put in place the mechanism that ends up being options 2 and 3 and 106 agreement. We're not saying that's inherently irrational. It's just outside the scope of the delegation. That's the point.
And just to go back to
your submission's very clear on that.
It only when we get to the floor, which I'll come to in a second, but that's a sort of subsidiary point.
I don't want to cut off my Lord's question.
No.
just really going back over yesterday, because these are the definite articles. Like, on one reading, it's a combination, it's the land and sum of money sufficient, not the land and a sum of money sufficient. There are two halves to the equation. They need the wherewithal to build the houses. Isn't it as simple as that?
They do need the wherewithal to build the houses, absolutely. But this is telling them how that wherewithal is to be framed, and it's the land sufficient to build, which is a piece of real estate, and it's also the sum of money sufficient.
Yeah, to build new housing, you need to have land to build it on,
Absolutely.
and the ability to build it because you can fund it.
Yeah, and absolutely, and that's correct, my lord. But the point about this paragraph is it's stipulating the way in which you're to be given the ability to fund it, because there is a material difference from the point of view of local authority of having cash and having a piece of property.
The argument is around the tightness or lack of tightness in the construction of these words, you say. They are to be, your submission is there to be tightly read, and they don't extend to the arrangements that were in fact put in place. That frames the whole of this argument, actually, that proposition.
Well, that's right. Only quibble in the what's the right word? The pejorative tone, which I'm sure my lord doesn't intend
There's nothing pejorative intended at all.
No, I don't mean. Sorry, that was the wrong word.
That's entirely the wrong word. Yes.
The loaded term.
It's not loaded either. It's meant as a general inquiry to assist us in identifying the issue we have to decide and the arguments for each side. No judge approaches a case in a loaded or pejorative way.
Well, that's right. I wasn't suggesting any of those things. You know me better than that. I wasn't suggesting any of those things. This is about the approach to construction. We say the approach to construction is the approach set out in Trump. I don't want to go back over that. And that is not about a narrow or tight approach. That's about how the ordinary councillor, in this case, because that's the operative person, would understand these paragraphs. In context, and the context is as I've described.
Just a question, going back to the meaning of the land, if I may, that was understood to mean the whole site, wasn't it? That's what happened in the 106.
No, it's only one building. It's only one building within the west side. It's not the whole of the west side that gets transferred under any of those options.
So if we look at the land edged red on the plans in Appendix 15, that's only part of it, is it?
I haven't got them in front of me, but I think I'm pretty sure that's only part of only one block in the west side. You heard from I can't remember Mr. Kalinsky or Mr. Harris about mansion blocks and so on.
Okay, so that's
it's not the whole of the west side by any stretch of the imagination at all. It's just one building.
It's the land. Thank you.
or one, not one building, sorry, it's not a building at all, one plot, but it's the plot for one building, it's not the plot for the whole of the west side. So the other aspect of this is partly from Mr. Harris and partly from Mr. Kalinsky, is a suggestion that somehow this gives the council an unlawful windfall, and that is partly put by reference to Regulation 122 of the civil regulations, but also put as a more general point by Mr. Harris. We said there's nothing unlawful or windfall about any of this, because recall that the developer's primary option, and indeed what we believe to be everybody's intention, is that the developer will just build the 116 or whatever any uplifted number is. That is their, we understand it, preferred route. It's what the council wants. It's what the claimant wants, and so on. So all of this is a fallback. It's a fallback which is seeking to deal with the situation if the developer doesn't do that for some reason. And there could be lots of reasons why that doesn't happen, good and bad. So this is then a perfectly, what we say 364 means and requires, a perfectly rational and lawful way of dealing with that situation, including in putting the council into the position of being able to build the social rented units without having to borrow money, which is a critical factor for cash-strapped local authorities. That's the fundamental thing. There's nothing out with the planning purposes or out with planning law or unreasonable or out with the civil regulations in any of that. This is a perfectly lawful mechanism to deliver up in the fallback where the developer doesn't do it themselves for whatever reason, these 116 units. And that's there's nothing impermissible about any of that. I'm not sure I can say more on that paragraph or those paragraphs. We've been around it quite a lot. The other point, this is again the last point in relation to Mr. Harris's note. In paragraph 40 and so on, he here deals with the floor point. My lords will recall that this arises under option 2, because in option 2 there is something called the net construction cost calculated, which sounds on the face of it, assuming you could take into account value, as being a satisfactory approach because it gives you the top-up cash. The difficulty, and this is the FLA flaw, is that top-up cash is, the calculation of it is conditioned by setting a floor, FLOOR, on the valuation of the land and setting it at 2019 prices. Now, paragraph 43, in Mr. Harris's note, he quotes from the judge, and the judge says this: the Section 106 agreement necessarily had to deal with matters in principle because it was seeking to deal with scenarios which might emerge many years after the obligation they entered into. Examining figures arising around the time the obligation was entered into are undoubtedly part of the background to 106, but so too is the common assumption that values would rise over the construction of the project. ... It's not being suggested this was an unreasonable or inappropriate assumption on which to enter into the agreement. The difference is that the proviso is precisely going in the opposite direction from the assumption that the judge has identified. If the assumption that underpinned the 106 agreement was prices will rise, all well and good, all well and good. But that's not what the proviso deals with. It deals with exactly the opposite, which is prices might fall. Prices might fall. But the proviso in question it's at page 457. That's not right, is it? Probably 457, sorry. 547. It's paragraph 3.1. It limits the scope of the effectively expert exercise, which should be undertaken at some point in the future. The expert exercise is what's the construction cost and what's the value of the land transferred. And that will give you on the face of it net SR construction cost, a cash top-up. But it conditions the valuation of the land by saying the valuation attributed in 2029 can't be below the 2019 level. So that's exactly the counter what the judge says the assumption that was being made was. So the judge's approach to that is completely the wrong way around. And indeed, the way in which this passage arose, we actually have the drafting here. If you go to page 334 in bundle showed you this yesterday. This is the December draft of the Section 106 agreement. Paragraph 3.3. This is interestingly, it's a tracked changes version that's being looked at this point. Paragraph 3.3, same numbering paragraph. Construction cost, net SR construction cost, to be calculated by the difference between the construction cost and the value of the land, but no mention of the proviso. So the proviso is not even in the track changes at this December version. It seemingly enters the picture at the very last stage, must be the dying days of the negotiation of the 106 agreement, to precisely undermine the very thing that the judge says was the assumption on the basis of which they were proceeding. It runs in exactly the opposite direction to the judge's identified assumption that land values will rise, because it deals with the exact opposite, which is what happens if land values fall. And the result of it, and this is where even on the, as it were, the council's own case as to what this mechanism had to do, the result of it is to make that mechanism an irrational one, because it leaves the council in the scenario which the proviso contemplates with a shortfall of money. And that is not answered by the fact that the council can go for option 3. Option 2 depends upon valuation of the land. So in a sense, they both succeed or fail together, and if land values drop, option 3 won't generate the money, and will option 2, and option 2 won't even generate the right cash. And that is why we say, even on the analysis that this was, as it were, a mechanism to be derived from first principles at that point, not conditioned by 364 at all, we say those mechanisms are irrational. Well, also, I'm not seeing any emails from behind. Miss Sackman will wave her arm. She's shaking her head, which I think is a no points to make. Unless I can assist the court further, those, at least for now, are our submissions.
Thank you very much. I'll just see if my colleagues have any questions for you at this point.
No, thank you, Mr. Wolf.
No, thank you.
Thank you very much. Thank you, Mr. Wolf. There is one outstanding request, which is a small request for the titles of the development plan documents, which I think will be agreed and submitted to the court. Thank you.
Well, yes, we'll make sure that's done, and I'll check with all the others. They're happy with that.
I don't believe there's anything else outstanding that stands as a request for further information. Thank you. We shall reserve our judgments. A draft of those judgments will be circulated in the normal way, and for typographical and minor factual correction, not for any substantive comment. The parties should agree an order insofar as they can, subject to any further submissions, and will be handed down, we assume at this point, in accordance with the relevant prevailing COVID protocol at that stage. Quite exactly what that will be, we cannot be absolutely sure at the moment, of course. But we anticipate no requirement for council to attend a hand down under those arrangements. Thank you all very much. I thank council for their very clear written and oral arguments, for their legal representatives in support of them, and I trust that the arrangements for transmission of these proceedings, despite the glitch we had this morning, have otherwise been satisfactory. Thank you all very much.
Thank you.